Good to see you again. Well, our topic today is appellate jurisdiction. Now, in both the federal system and in California state court, as well as in many other state courts, there are pretty strict rules about when you can take your first appeal as of right to the intermediate appellate courts. When appellate jurisdiction exists, the appellate court has an obligation to take the appeal and exercise its powers of appellate review. And the fact that appellate jurisdiction, when it exists, is mandatory is precisely why the federal courts and most states have adopted the final judgment rule, so that you generally can take your appeal only when the trial court has issued its final judgment and is done with the case. Appellate courts simply could not function at their current resource levels if every decision by a trial court were appealable. So we limit the flow of those cases through the final judgment rule. Now, the final judgment rule means that most trial court decisions are not subject to immediate appellate review. And this is not because trial courts don't make mistakes. It is just that we don't have enough appellate resources. And as a practical matter, if every trial court decision were immediately reviewable, proceeding to the trial court level would be routinely interrupted and would take a lot longer. But let's be clear that filing an appeal is not the only way of trying to get an appellate court to review what the trial court has done. In every jurisdiction, in addition to filing appeals, a litigant can file an original action in the appellate court, usually called a petition for a writ of mandate, asking the courts of appeal to correct some trial court error. But the difference between an appeal and an appellate proceeding on a writ of mandate is that the appellate court is required to take the appeal, while the court exercises its own discretion in whether to grant a petition for a writ of mandate. And the standard for granting a petition for a writ of mandate is pretty high, with the appellate courts requiring clear error by the trial court and a mandatory obligation to proceed. Because of that high standard, around 97-98% of the petitions for writs of mandate get denied. And those denials happen very quickly. Within 3 to 5 days, the appellate court knows whether it's going to grant the petition for a writ of mandate. Because you see, the appellate court knows that the pendency of the petition for a writ of mandate may interfere with proceedings in the trial court. So they move very quickly on those petitions for writ of mandate. As a result, trial counsel really needs to reserve petitions for writs of mandate to only the most important trial court decisions, and only those decisions where, in the judgment of trial counsel, it really is clear the trial court has made a mistake. You don't want to waste everybody's time and money and resources taking lots of petitions for writs of mandate during a trial. Now, in addition to appeals after final judgments and the possibility of petitions for writs of mandate, there is a third way of getting appellate review of certain types of trial court orders, which involves taking interlocutory appeals. Interlocutory appeals have been authorized from those few trial court orders that almost inevitably affect not only the progress of the litigation before the trial court, but also affect the rights and duties of the litigants outside of court. Now, in particular, as the materials indicate, a litigant can take an interlocutory appeal from an order granting, continuing, modifying, refusing, or dissolving injunctions, or refusing to dissolve or modify injunctions. This language makes decisions about preliminary injunctions appealable. Now, you might think that this language also makes TROs appealable, since they are similar to preliminary injunctions. Well, you would be wrong about that. A temporary restraining order is a TRO. It is not a preliminary injunction. And the courts have held that a TRO is not an appealable order. Now, there is actually a great deal of common sense to this rule. A TRO is supposed to exist for only a short period of time anyway, something like 20 or 30 days at most. So it doesn't really make practical sense to permit an appeal from decisions about TROs, because the appellate process is a lengthy one that would hardly have even begun to gear itself up in those 20 or 30 days. In other words, action at the trial court level would make the appeal from the TRO moot in almost all cases. Now, that does not mean that decisions on TROs can never be reviewed by an appellate court. First, a litigant can seek review of a clearly erroneous decision on a TRO by filing a petition for a writ of mandate. Second, appellate courts can give guidance about TROs when they review appeals from decisions about preliminary injunctions. After all, the standards are the same. So, the lack of immediate appellate review of decisions on TROs is not really a big problem. Now, I have one last set of comments about appeals, and that deals with the topic of stays pending appeal. When an appeal is taken from a decision on a preliminary injunction, or a trial court issues a permanent injunction, and then an appeal is taken from that judgment, the question may arise whether the preliminary or permanent injunction is supposed to be effective while the appeal is pending. In the federal courts, an appeal from an injunction does not automatically stay enforcement of the injunction. Instead, the appellant must generally ask the trial court to stay its order pending appeal, and if the trial court refuses, then the appellant can file a motion with the appellate court asking it to stay the injunction pending the appeal. In analyzing whether to grant a stay, both the trial court and the appellate court analyze the issue using the same 4 factors used to decide whether to issue the injunction. So the courts consider whether the appellant will suffer irreparable injury from the injunction pending appeal, the likelihood of the success of the appeal, the balance of hardships pending appeal, and the public interest. Now, as you might imagine, the trial court usually is going to deny the appellant's request for a stay, since the trial court is the court that just entered the injunction. But this is not always the case. Sometimes a trial court will grant the injunction, but realizing that there may be substantial harm from trying to enforce the injunction pending appeal, will actually stay its own order pending appeal. If the trial court does not grant the requested stay, then the litigant needs to raise the issue with the appellate court. One last refinement on stays pending appeal. In California State Court, there is a special rule that a mandatory injunction is automatically stayed when an appeal is filed. Now, to understand this rule, you need to understand the difference between a mandatory and a prohibitory injunction. A prohibitory injunction is one that forbids the defendant from taking some action. Don't do this. A mandatory injunction is one that compels the defendant to take some action that changes the status quo. I order you to paint the house. The idea behind California's special rule is that a mandatory injunction is more intrusive than a prohibitory injunction, since it requires the defendant to take some action instead of merely maintaining the status quo by forbidding the defendant from taking some action. And because a mandatory injunction is more intrusive, it should be automatically stayed until an appellate court has a chance to review the mandatory injunction. Now, distinguishing between a mandatory and prohibitory injunction at times can be a difficult thing to do, because as you all know, it is pretty easy to draft a positive into a negative. That's what lawyers do, and a negative into a positive. Courts try to get around that drafting problem in gamesmanship by looking not to the way the order is drafted, but to the actual impact of the order upon the defendant, whether the order forces the defendant to take action, and whether it changes the status quo between the parties. My own view is that California's rule is unnecessary and unwise, because it does promote a certain amount of gamesmanship into the drafting of injunctions. And you really don't need an automatic rule, since the appellate court can always protect the appellant's rights, if need be, by entering a stay pending appeal. So instead of having an automatic rule, it seems to me this issue is best left to the discretion of the trial and appellate courts, which is the way it's done in the federal system. Well, okay, it's time for you to go back to the materials and take a look at a case that raises the issue of whether a TRO is always a TRO, or may sometimes be treated for appellate jurisdiction purposes as a preliminary injunction. And I'll see you again when you get to the materials on standards of appellate review. Au revoir.